In a landmark legal case, Meta and Google have been found liable for social media addiction. The jury at the Los Angeles County Superior Court has delivered its verdict, and it's stated that the two tech giants intentionally built addictive social media platforms. You don't say. Now, after the decision, the mothers of children who committed suicide gave this emotional testimony after the verdict.
I'm kind of I think we're all out of words to express what we feel, and being in that courtroom and hearing those answers from the jury, it's really validated, been a complete validation of what we've been screaming on the top of roofs about for years. It was not an accident, and parents are not to blame. That's for sure. They knew the harm, right? They knew the damage, they assessed the risk, and they moved forward anyway.
I'm really torn about this topic with all those mothers standing there, no doubt having been through trauma and grief and the most awful, awful loss you could possibly imagine. But is it really the fault of the mobile phone? I think it's much more complicated than that. Now, in a statement following the verdict, a Meta spokesperson said that they respectfully disagree with the verdict and are evaluating their legal options. They added that they intend to appeal the ruling. Jose Castaneda, a spokesperson for YouTube parent company Google, said the platform plans to appeal the ruling, adding that the case misunderstands YouTube, which is a responsibly built streaming platform, not a social media site. Let me talk now to New York trial attorney James Rubinowitz. James, thank you for joining me. Give me a little bit of detail here, James. Who brought this case? What have they proven? And what have they walked away with?
So almost every person you're going to see on TV tonight is going to speak about the monetary award that plaintiffs received in this case, which was $6 million, which is far less than what the trial attorney, Mark Lanier, requested at the end of the trial, which was a few $billion. But what people will not focus on is the impact this will have on Meta, on Google, and the rest of the social media companies. Because the reality is California is a very unique place to try a case, because they will focus on punitive damages in a way that other states will not. As you mentioned, I'm a trial attorney in New York, which means I would need to prove in New York that Meta and Google's actions were tantamount to intentional conduct. But in California, all you need to prove is that it was malice, oppression, and fraud. And that is exactly what the plaintiffs here proved. So although it was a $6 million case, there are remaining 10,000 plaintiffs that will have cases against Meta and Google. So this can be a windfall against all of these social media companies. So I'm curious to see what is going to happen after this case.
Hang on a minute, James. My mind is blown here. So the plaintiffs in this case got $6 million. What did they argue those damages were for? What damage had been caused to them in order to earn such a lot of money?
And that is a fantastic question. So the first $3 million is compensatory damages. What I mean by that is this is intended for their mental injuries. So the plaintiff, for example, because she was 13 when she first started going on Facebook, she posted more than 200 selfies of herself when she was 13 years old. This was one of the most pivotal moments of the trial when Mark Lanier brought out a 35-foot poster board with all the selfies of her and confronted Mark Zuckerberg himself with this poster board. And Mark Lanier was making the argument that Mark Zuckerberg was like a lion taking advantage of other prey on the prairie. It was pretty powerful. And it's one of those things where the $3 million for a jury was argued to be for her mental health damages. It's true, Google and Meta both made the arguments that there are so many other things that would cause a 13-year-old to experience anxiety. But the reality is, and Mark Lanier himself, the plaintiff's attorney, brought a cupcake to make this argument, which is a little ridiculous, but it was pretty powerful. He said, you know, in order to make a cupcake, you need to put in a lot of ingredients. There's frosting, there's flour, there's baking soda. If you leave one of the ingredients out, you're not going to have everything. So just like a 13-year-old who, of course, has stresses at home, they have stresses with friends. But the reality is, in order to have stress the way that would basically prompt a 13-year-old to post 200 selfies, that, of course, is related to Facebook. And the second way, the $3 million that made it 6, is punitive damages. That is intended to punish Facebook.
Fascinating. And so I would presume if I was trying to defend Facebook, I'm no lawyer, James, but if I was trying to defend Facebook, I would say to the mother of that child and the father, what role did you play in trying to stop your daughter posting 200 selfies? Why couldn't you take responsibility for your own child? Did they do that? And if so, what happened?
I think Mark Lanier, the plaintiff's attorney, did a fantastic job in arguing this. And what he said throughout the trial, the common theme was ABC, which was incredibly powerful. And what he said for ABC will blow your mind. It was addicting the brains of children. And he said it time and time again throughout trial. It was powerful. You saw the jury react to it. And you're absolutely right. What were the parents doing? But I think the reality is no parent can compete against an addictive platform like the 6x3 phone in your hand. You're constantly swiping. I know I do it. You go down a doom scroll. And the bottom line is the argument was it's addictive product. And so this is something that was incredibly unique. They were able to make the argument that this is not necessarily a parent's fault because it was a product that was designed to be addictive.
So can we all now take them to court, James? Because I am definitely addicted to Instagram and to Twitter and to Facebook, and I will go back to my WhatsApp 52,000 times a day. So am I in line for $6 million now?
Well, I hope I am too. I know my fiance would probably say in the mornings and in the evening, I probably am also addicted. But this is strictly a case that is intended for children, and children before Facebook, or excuse me, Meta, Google changed their actions to basically make it so it wasn't as addictive anymore. So I'm really hoping we don't have to be able to bring the suit because we won't be addicted, but you could ask my fiance.
Oh, well, but can you foresee a time when an adult would say, I haven't got a job because I can't get out of bed in the morning because I can't get off Instagram. I didn't get married because I spent all my time on TikTok. Is it foreseeable that adults could take these cases to court as well?
I absolutely think yes. And the reason being, again, is because this was a case that was not something we've seen in the past. In the past, we've seen Section 230 of federal law, which essentially said that you were not able to sue any type of social media company. It was instead the individual poster who was responsible, and the social media company did not have to police these posts. But now what we're seeing is a very unique case, which is what this case is a landmark case of. We're seeing essentially an argument made that this is a products liability case. And in fact, Facebook, Google, so on and so forth, they've made this product intentionally addictive. So adults and children will be able to bring cases against the social media companies. It's very interesting.
Just one last question, because I could talk to you for the next 90 minutes we're on air, but just one last question. Will this mean that these companies will change their algorithms? Because their algorithms, their business model is predicated on these algorithms being addicted so that you stay watching longer. They get the advertising revenue. You're more likely to click through to the products. Will they be forced, James, to dial that down?
I hope so. That is the real answer I can give. And the reality is the problem right now is Congress and our state legislatures are having difficulty passing laws. And we know this because both parties can't agree on anything. So what we're instead doing is relying on our court decisions to basically dictate what the law is. So my hope is this judgment is big enough because even though it's $6 million, there are tens of thousands of potential plaintiffs. So I hope it makes a big enough statement to all the social media companies to stop making it so addictive.
Absolutely fascinating. Hopefully I'll never need one, James, but if I need a New York trial attorney, I'm calling you. James Rubinowitz there. Thank you so much for joining us. Right. Wow.